Our argument is that the transaction advisors
Yes.
were irregularly procured without any competitive bidding.
Yes.
Our third point, my lord, my ladies, is that the expected sale proceeds, that using the expected sale proceeds as revenue contravenes Article 209, Articles 209 to 214 of the Constitution.
Yes.
My lord, my ladies, the Cabinet Secretary failed to submit to the National Assembly a privatization program contrary to Articles or Section 22, I believe, Section 22, 2 of the Privatization Act.
Yes.
My lord, my ladies, we also argue that there was absence of public participation, a cardinal requirement in our country as it is today.
Okay.
And then fifthly, my lord, my ladies, failure to consider national security interest. In the sessional paper, as I said earlier, in breach of Section 22(2)(d) of the Privatization Act of 2025.
Yes.
Security, my ladies, is critical. This country is gearing itself for an election year next year. Transmission of election results normally is done through Safaricom and all. Never mind, my ladies, that sometimes they have been misused to give information regarding the now notorious abductions that have been visited upon the population of this great nation.
Okay.
So, my lord, the many agents, mama bogas who rely on or do their transactions in the millions, we had occasion to highlight that, my lords, my ladies, in our earlier submissions. A measure of being dispossessed of this vital national asset, which will now clearly be foreign owned. Through the Vodacom group.
Yes, continue.
My lord, my ladies, I now yield the floor to Council Lempa to continue with the highlights.
Yes.
I thank you.
Yes.
Okay, thank you very much, Senior Counsel. Lepa, and be precise and do not rehash what you have already written. Give us the specific details which you think that would require our attention.
Yes, thank you.
Lepa, continue on that basis.
Thank you, my Lord, my ladies. Our amended petition is dated the 22nd day of April 2026. It is supported by the affidavit of Musyoka,
Yes.
dated the 16th day of June 2026. For the affidavit.
Yes.
My Lord, it is also supported by the affidavit of Irongo Nyakera. Irongo Nyakera, I'll get the date. I'll get the date, my Lord. And the submissions, our detailed submissions, dated the 16th day of June 2026. My Lord, and before I proceed, I would like to bring to your attention, and under section 60 of the Evidence Act, that this court should take judicial notice that today Safaricom share was selling opened at 34 shillings and 40 cents. 34 shillings and 40 cents. That is judicial notice. And therefore, courtesy of your conservatory orders and the status quo orders by Justice Mugambi, your brother, this country has been saved of 2.4 billion shillings today. The money that John Bandigongo and Dorcas Oduor Agik Odong wanted to throw away. My Lord, without necessarily rehearsing on what my senior counsel has said, our submissions have a number of parts. We have the fact from paragraph 1 to paragraph 57, where we begin the analysis. But my lords, my ladies, we would like this court to take close attention to paragraph 2 of the written submission, where the divestiture sessional paper states that they want, or the objective of this divestiture, of this ignominious divestiture, is to raise revenue. My learned senior counsel has elaborated that the Constitution under Part 3 does not allow John Badingongo and Dorcas Agik Oduor to raise revenue using Part 3 of the Constitution. That is in paragraph 4. My lords, my ladies, would also like you to pay close attention to paragraph 5, where the sessional paper in paragraph 1.72 describes the would-be purchaser, the said shares of Vodacom Group, the seventh respondent, a foreign entity wholly owned and controlled by unknown shadowy persons. Watu ambao hawajulikani, shadowy persons. While
are you referring to the submissions?
Yes.
Submission?
Submission. Yes. Paragraph.
Do you mind repeating what the Constitution does not permit?
The Constitution does not permit the state to raise revenue using Part 3 of the Constitution. It is well elaborated. It will come clearer as we go to specific details to that. But we are saying that on paragraph 5, the first respondent sessional paper, which is paragraph 1.72, describes the would-be purchaser of the same shares as Vodacom Group, which is the seventh respondent, as a foreign entity wholly owned and controlled by unknown shadowy person. While on the other end, the press release dated the 3rd day of December 2025, which is annexed to the affidavit of Tony Gachoka, of the supporting affidavit dated the 22nd day of April 2026, projected the 8th respondent being the Vodafone Kenya Limited, as the would-be purchaser. They are introducing a purchaser by a press release, not in the sessional paper itself. Hello? Going down there, it is very clear that the way the respondents have treated this particular divestiture it's shrouded in mystery. You know, my learned colleague, my learned senior, wishes to challenge expert opinion on a technical issue. The ordinary and proper course is to adduce contrary expert evidence and mere assertions by counsel or lay witnesses, like John Badimomo is a lay witness, like Dorcas Odur Agik is a lay witness, are generally insufficient to displace a properly founded expert evidence. So that the question we pose, is the evidence of Irungu Nyakera a properly founded expert evidence? Yes, it is. Is Dorcas Odur Agik an expert witness? No, she is. She isn't. No, she isn't. Is John Badingongo an expert witness? Indeed, he is not. And therefore, we urge this court and we submit humbly that you treat the entire expert witness by Mr. Irungu Nyakera, who is a financial engineer, as uncontroverted. And the uncontroverted evidence, my lords, my ladies, is nothing but evidence of how the state has undervalued the shares of Safaricom company, the shares that they hold in trust for the people of the Republic of Kenya. Safaricom is not your ordinary telecommunication company. It's a strategic sovereign property whose divestiture cannot be done at the speed that John Badingongo and Dorcas Odur wants this court to adopt. But in our part B, we have raised the following questions for determination: whether the government can use Part 3 of the Constitution of Kenya and Section 74 of the Privatization Act to raise revenue as per the objective of sessional paper number 3 of 2025. That is well elaborated, and I don't wish to meditate on what has been written. It is well explained from paragraph 31 all the way to paragraph 57, with well cited cases from both the local jurisdiction and international jurisprudence. My lord, I think we have quoted the case of South Africa to support how this government or this particular regime is not allowed to create its own way of raising revenue outside of the Constitution, Article 209 of the Constitution of Kenya 2010, which some of the proponent of this particular legislature opposed vehemently. The Constitution of Kenya 2010. As to whether the proposed sale of government shares in the 6th respondent violates Article 1 because of the sovereignty of the Kenyan people, Article 10, people participation, and in people participation, my lord, paragraph 76 is very clear. And it is even very sad that John Badingomo did not conduct public participation in his Suba county, so in his Migori county where Suba constituency is. He did not. While we could actually forgive him for not conducting it where I come from, in Narok, because it is there, and Lamu. But of course we know these are traditionally marginalized counties. But John Badingomo did not even conduct people participation in his own county. I don't know where Dur comes from. Maybe my good Richard Marwa can tell me, but I suspect he did not also conduct. She did not also conduct public participation. My lord, my ladies, we are highlighting 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17 counties. 17 counties, no people participation was conducted there. And there is no village in this country where there is no M-Pesa shop. And we are being told, they are blowing it, talking about how effectively we conducted people participation. It's a lie. And it is a lie by John Badingomo to Parliament and to this court.
Yes, continue.
My lord, from paragraph 104 is to whether the impugned transaction complied with the mandatory requirement of the Privatization Act 2003 and Public 2005 to 2025 and the Public Procurement and Asset Disposal Act 2015 and the applicable Capital Markets Authority. We have quoted cases and we have given facts as defined by our petitioner and expert witnesses that this indeed was done wrongly. Lord, we proceed. We have quoted cases, we need not rehearse them, they are in black and white.
Yes, Lepa, continue.
My Lord, insofar as the divestiture of 15% of the Safaricom company is concerned, we are saying that the government does not, just as they were advised by the Law Society of Kenya and they ignored that particular advice, that they are not allowed to sell companies that are profitable. The only window that are given to them is for them to sell unserviceable, obsolete, obsolescent and surplus assets, of which Safaricom PLC is not part of. Lord, in our paragraph 144, whether the transaction unlawfully undervalued the strategic national asset in valuation of constitutional principle governing prudent public management and protection of public resources. We have exhaustively explained that, and we have exhaustively indeed demonstrated how Article 10, Article 201 have been violated. Lord, I wish to refer this court to paragraph 149 on what the expert witness said about an evaluation. In 149 he says, the transaction of Kenya price 1434 per share is materially below the fair value of Safaricom PLC as at December 2025, my weighted central fair value estimate at Kenya shillings 57.90 per share, with the range of Kenya shillings 47 to Kenya shillings 77. The discount of Kenya shillings 23 or 43% represent foregone proceeds to the public of Kenya approximately Kenya shillings 143 billion shillings. That is what the Kenyan people whose shares are held in trust by the state is losing. Going to our paragraph 148, whether the intended transfer of effective majority control over the six respondent retains Kenyan sovereign national security competition framework. My learned colleague, Senior Counsel Kalonzo, has explained that, but if you want to get the finer details, you get it from paragraphs 148 all the way. You know, my ladies, you will be persuaded that the shares that we are talking about are floated in the Nairobi Security Exchange, and any one person can buy. You know, we continue arguing that a secondary IPO would have sufficed. And our argument to this fact is that a secondary IPO would be even cheaper than the market price. And the Kenyan people, including the generation Zoomers or Gen Zs, who are not mature, by the time Irongo Nyakera, our expert witness, opened Safaricom IPO in 2007, were not mature. It is the desire of the Gen Z to have a bite at the cherry. Hata wao wapate nafasi ya kumiliki kampuni hii ya Kenya ambayo inamesewa mata na serikali ya Rais Ruto. Do not disregard any persuasion that these shares, even if they are floated, will be bought by foreigners. At least they have disclosed that indeed we intend to sell this company to foreigners. And in those few remarks, I invite my good friend and colleague, Mr. Zaku, to summarize.
Yes, my ladies and lordships, I associate myself with Mr. Zaku.
Zaku.
Yes, my lord. I associate myself with submissions by my senior colleagues. And what I'm saying is that, my lord, we are selling this company to a foreign entity. That is what it is desired. And to sell such a company to a foreign entity, it is a company which holds very sensitive data of the petitioner and 50 plus other Kenyans, or 50 million, who hold a Safaricom line. My lord, that information for every registered SIM card holder is protected under Article 31 of the Constitution, that such information which is tied to the shares in Safaricom cannot just be transferred to a foreign entity. This court differently constituted, and as recently as on 19th March 2026, in the case of Erastus Gura of Thiambo versus the state, petition number E290 of 2024.
So are you introducing some new authorities that have not previously been cited?
I am guiding the course.
Lord, we're here to highlight submissions which rely on authorities to which we have had prior notice. He cannot just decide that he will introduce his own authorities at this stage.
My learned colleague, Mr. Zaku, is an officer of this, and he cannot be gagged from introducing an authority.
Yes, my lord.
Zaku.
Yes, my lord.
Zaku, Did you find that authority?
That's, my lord, is a recent authority. We've not filed it, but it's a key authority in this matter. That the court cannot ignore it. This is a court of law,
So,
and it's guided by
no,
the law.
we have noted it, but don't submit on it because the other council will not have an opportunity to reply to what you are saying.
Very well.
Continue on the other aspects.
My lord, we have said that digital data held by Safaricom, it's an information that cannot be transferred to a foreign entity, and as such, that would be my submission as regards that issue of data protection.
My lord,
Is that all, Zaku? You are completed?
yes, yes, and to cap it, my lord, my ladies.
Yes? That's Senior Kalonzo?
Yes, yes, my lord. Yes, my lord.
Okay. Then in 3 minutes?
Yeah, to cap it, my lord, my ladies, we want to make it very clear, perhaps not even a matter for this court to note, but this matter is of great national interest. And 1 year to an election, my lord, my ladies, and taking into account what I earlier noted, the granting of the application by the respondents, setting aside the conservatory orders issued by this court, and being apprehensive of the necessary actions, next actions, my lord, my ladies, we should not take it against us when we issue statements and caveat emptor. Let the buyer be aware. All of this because national interest must be protected. We managed to stop the sale of the Jomo Kenyatta International Airport until President Ruto himself had to come out and say, stop it. I want to invite him to consider the same statement in view of the great interest this matter has evoked. Because my learned friend wa Tanzania anamwita wakili msomi. Wakili msomi mwenzangu, anawaita majina yao, lakini ukweli ni kwamba they serve under one authority, the President of the Republic of Kenya. I invite him to exercise prudence and high consideration of national interests. His predecessor, Uhuru Kenyatta, could not have dared to touch Safaricom. We rest our case, my lord, my ladies.
All right. Thank you very much. There was another petitioner.
Yes, my lord.
Yes, Kiara, do you wish to make any submission and do not repeat what has already been stated, eh?
Yeah. Give me like 2 minutes, my lord. I read it.
2 minutes?
Yeah. I want land to raise courts for previous orders. Na niko hapa kuunga mkono hii petition ya E051 na niko na huzuni, my lord, kwa sababu wakati tulienda serikali ilienda wa Court of Appeal, sikusabiwa na the relevant documents na nika complain, but they proceed to the matter in the Court of Appeal. Nimekuja hapa leo kwa kulia nikisema na nikiomba koti leo mchana ya leo, Safaricom is our heritage in this country, our brand that ikiuzwa iende kwa nchi ya kigeni hatutaweza kuipata tena. So kwa leo naweza omba koti ama niseme niko hapa kama Mkenya na nimekuja nikiwa binafsi, nikiomba koti isikie ile kilio ya Wakenya wengine milioni 50 wenye hawana uwezo wa kufika mahali hapa. Sina mengi kwa leo, but naweza omba koti isikize hiyo ombi. Asante.
Alright, asante Saidi. So is Ogola here now? Professor Ogola, are you here now? Professor Ogola is not here. So I think now we'll now go to the respondents.
I'm told Professor is on hold, is waiting to be admitted to the lobby.
There's nobody in the lobby. I'm the one who is admitting people, and I've admitted everybody. I've admitted everybody. I'm the one admitting the people. And I keep on admitting while we proceed. So in which lobby? Because he's not in my lobby. So I think we assume that he is absent. After all, we have made very extensive and profound submissions for the entire case. So we proceed now with the respondents. John Waka, and also be brief, because we are going to read the submissions which have been filed and which we find to be quite detailed and comprehensive. John?
Thank you very much, my lord. Your leadership. I see that Kalonzo Musyoka Senior Counsel has departed. We have listened very carefully to the case of the petitioners.
Yes.
We have given consideration to the submissions as well as to the matters put forward in the amended petition and the supporting affidavits. My lord, the respondent's case is simple and straightforward.
Yes.
In our respectful submission, the petitioners have built their case on the wrong legal foundation. They ask this court to treat this matter as a privatization program falling under the Privatization Act, and simultaneously ask that you treat it as a public procurement matter falling under the Public Procurement and Assets Disposal Act.
Yes.
My lords, both of those acts, at section 4 of each of those acts, exclude the sale of shares from the ambit of those acts. And we have set out the precise provisions in our written submissions. it is difficult to understand why the petitioners choose to ignore the statutory route created by Parliament for the sale of shares in a government-linked corporation.
Yes?
The first duty of this court, therefore, my lord, your ladyships, is to identify the correct statutory route for the sale of these shares. In our respect to the Constitution.
Yes?
The third issue we want to deal with relates to the attack on the cabinet approval, the parliamentary approval, and public participation. Well,
Yes?
the transaction has been alleged to have been conducted secretly in an opaque manner and without the requisite adherence to the provisions specifically of Article 10 of the Constitution.
Yes?
Well, we have demonstrated in the 3 affidavits sworn by the Cabinet Secretary
Yes?
that a sessional paper and accompanying explanatory material went to the National Assembly subsequent to the Cabinet approval. The Joint Committee of the National Assembly considered the sessional paper, undertook extensive public participation, and the National Assembly approved it by resolution.
Right?
We have set out, my Lord, 78 stakeholder institutions were engaged. Public participation forums were held across more than 30 counties. 32 sittings considered the valuation, the identity of the purchaser, questions relating to employment, governance, competition, consumer protection, data sovereignty, and national security. It is not the law that every objector who presents his views must have those views embraced unconditionally. The test, and I need not remind your lordship, your ladyship, the test is one of reasonableness. We have given you the Supreme Court's decision on British American tobacco for the proposition that public participation must be real, not illusory, and must provide reasonable notice and reasonable opportunity. In our respectful submission, that threshold has been met.
Okay.
There have been allegations of fraud against Parliament. No particulars have been supplied. And those allegations have not been proven. It is not sufficient to place rhetoric before the court and make allegations of such a serious nature as fraud. Fraud, as we know, must be pleaded with particulars and must be proved.
George, you should be winding up, eh?
I am making progress towards winding up a lot. Let me next deal with the question of pricing and valuation. Because clearly, this is at the center of the petitioner's case. But it is also where the case is most ambitious, but least proven in our respectful view. What the petitioners ask this court to do is to sit as a valuation tribunal. This court is not a valuation tribunal, neither is it a valuation committee. The court's role is to assess the legality of the transaction based on the material placed before it. Mr. Lempar, to his credit, has looked at the share price this morning. He bought? Yes. Oh, he's even bought the shares this morning. Congratulations.
Yes.
And referred you to section 60 of the Evidence Act. I did not remind the court that the material time is December of 2025, when the transaction was contemplated and sought to be entered into by the government. Share pricing is dynamic. It is affected by numerous factors. And if the petitioners had not interfered with this transaction through the launching of this petition, to which they are perfectly entitled, this purchase price would have come in 6 months ago.
Yes.
So it is not sufficient to cite today's price and allege on that basis that there is an undervaluation. Neither is it sufficient to ask that one expert's opinion be preferred is to determine the legality by government. In our respectful submission, the evidence placed before you by the Cabinet Secretary is to the effect that professional transaction of all the factors, they had consideration to the numerous valuation methodologies, and they advised the government on what they considered to be a reasonable price with a premium based on comparative jurisprudence, specifically the decision of the Supreme Court of India in Balco Employees Union versus and Act. The petitioner's expert opinion is not proof of unconstitutionality. Beyond offering his opinion on what the price ought to have been, Mr. Jakera has proceeded on the assumption or on the theory, on the theory that the price would be higher if M-Pesa was to be carved out. But M-Pesa is part,
Yes.
and the suggestion, therefore, that a higher price would have been obtained is based on a faulty theory that we submit this court should reject. In the end, my Lord, Your Ladyship, the petitioners have not proved an undervaluation. They have just proved that they would prefer a different model. That is not sufficient to override the cabinet approval and the National Assembly's approval, national security, Articles 35 and 65, and the question of competition.
Yes.
All of these arguments, my Lord, proceed on the mistaken basis that sovereignty, data protection, national security are preserved by shareholding. Well, the sale of this shares does not suddenly dissolve Kenyan municipal law.